Chapter 32, Reformation and Cancellation. Analysis. Section 675. Reformation for mutual mistake. Reformation is appropriate in cases of mutual mistake, that is, when an agreement has been made, or a transaction has been entered into or determined upon, as intended by all the parties interested, but in reducing such agreement or transaction to writing, through the mistake common to both parties, the written instrument fails to express the real agreement or transaction. In such a case the instrument may be corrected so that it shall truly represent the agreement or transaction actually made or determined upon according to the real purpose and intention of the parties. It is to be observed that the mistake which is ground for this relief must be in reducing the contract to writing. In every case, it must clearly and satisfactorily appear that the precise terms of the contract had been orally agreed upon, and that the writing afterwards signed fails to be, as it was intended, an execution of such previous agreement, but, on the contrary, expresses a different contract. A court of equity will not make a contract for the parties. The mistake may be either as to the contents or the effect of the instrument, but the mistake of both parties must be in regard to the same matter. Section 676. Unilateral mistake. Fraud. It is generally laid down that reformation will not be awarded on account of a mere unilateral mistake, a mistake of but one party standing alone. The reason is that in such a case there is no meeting of minds, no contract. A court of equity has no power to alter or reform an agreement, since that would in reality be making a contract for the parties. It is only the instrument evidencing the agreement that can be reformed. A unilateral mistake may be a ground for rescission, and sometimes cancellation will be decreed. In a few cases, where the facts seemed to warrant it, courts have made a decree for cancellation conditional upon a refusal of the defendant to consent to reformation. This, however, is an instance of the flexibility of the equitable jurisdiction rather than an extension of the remedy of reformation. Where, however, the instrument does not express the true intent of the parties, owing to mistake on one side coupled with fraud or inequitable conduct on the other, relief will be freely given. The ground of the jurisdiction in this case is the fraud of the defendant, rather than the mere mistake of the plaintiff. Section 677. Illustrations. Mistake of law. If, after making an agreement, in the process of reducing it to a written form the instrument, by means of a mistake of law, fails to express the contract which the parties actually entered into, equity may grant reformation, to the same extent as if the failure of the writing to express the real contract was caused by a mistake of fact. In this instance there is no mistake as to the legal import of the contract actually made, but the mistake of law prevents the real contract from being embodied in the written instrument. In short, if a written instrument fails to express the intention which the parties had in making the contract which it purports to contain, equity will grant its relief, affirmative or defensive, although the failure may have resulted from a mistake as to the legal meaning and operation of the terms or language employed in the writing. Among the ordinary examples of such errors are those as to the legal effect of a description of the subject matter, and as to the import of technical words and phrases, but the rule is not confined to these instances. Section 678. Illustrations. Continued. If one should execute a release so broad in its terms as to release his rights in property, of which he was wholly ignorant, and which was not in contemplation of the parties at the time the bargain for the release was made, a court of equity may either cancel the release or by reformation, restrain its application as intended. Where the same mutual mistake has been repeated in each one of a chain of conveyances, under such circumstances as to entitle any one of the vendees to a reformation as against his immediate vendor, the equity will work back through all, and entitle the last vendee to a reformation against the original grantor. Similarly, it has been held that if there is a mutual mistake in a mortgage in the description of property, and the same mistake is continued in the foreclosure decree and in the sheriff's deed to the foreclosure purchaser, equity will go back to the original transaction and reform the mortgage and decree as well as the deed, so as to make them conform to the intention of the parties concerned, though in other cases such comprehensive relief, under these circumstances, has been refused. Relief will not be given when the contract, as reformed, will have the same effect as before. nor if even after reformation it will still be invalid, and it has been held that it will not be awarded to give a party a remedy exactly equivalent to one he has lost by his own lackeys. Section 679. No reformation in favor of a volunteer. As a general rule, equity will not interfere in favor of a volunteer. Hence no relief will be awarded to a grantee in an imperfect conveyance which is not supported by either a valuable or meritorious consideration, against either the grantor or his representatives. A creditor taking the instrument either in payment or as collateral security, is not a volunteer, within the meaning of this rule. In some jurisdictions it is said that the rule is subject to the exception, that after the death of the donor equity will interfere to rectify a disposition which is clearly proved to have failed, through mistake, to carry out the donor's intention. While reformation will not generally be granted in favor of a volunteer grantee, it will be given to a donor who shows that, through mistake, his deed does not carry out his intention. Section 680. Negligence, lackeys limitations. The mere neglect or omission to read or know the contents of a written instrument is not necessarily a bar to reformation. The relief is proper when the instrument fails to conform to the agreement between the parties, through mutual mistake or mistake coupled with fraud, however the mistake may have been induced. The doctrine of lackeys is applicable to these suits, and in some jurisdictions the statute of limitations is expressly made applicable. The rule is here, as in all cases of fraud or mistake, that the time does not begin to run until discovery of the mistake or until it ought to have been discovered. Section 681. Parties against whom reformation may be had. Reformation may be had against a party to an instrument, and against anyone taking from him without consideration or with notice. Accordingly, a purchaser or mortgagee who takes with notice is in the same position as the original party, so far as this remedy is concerned. A bona fide purchaser for value, and without notice, however, is not subject to the equity of the party injured by their mistake, and there can be no reformation against him. In most jurisdictions, the equity for a reformation is superior to the liens of subsequent attaching and judgment creditors of the defendant. In states where a married woman's deed must be executed with certain formalities, no reformation on account of defects arising from non-compliance with statutory provisions will be decreed, since it would not only contravene the policy of the law but require her to make a contract which she has not made. A mere mistaken description in her executed conveyance may, however, by the preponderance of authority be corrected against her, and in some states where there are no disabilities upon a married woman's power to contract and convey, an instrument may be corrected as against her to the same extent as against any other person. Section 682. Parole proof, amount of proof. It is the generally established rule in the United States that parole evidence of mistake is admissible in all cases and for all purposes, notwithstanding the fundamental doctrine of the law of evidence that parole proof is not admissible between the parties to vary a written instrument, and notwithstanding that the effect of the parole evidence may be to enlarge the scope of an instrument required by the statute of frauds to be in writing. The authorities all require that the parole evidence of the mistake, and of the alleged modification, must be most clear and convincing. Or else the mistake must be admitted by the opposite party. The resulting proof must be established beyond a reasonable doubt. Courts of equity do not grant the high remedy of reformation upon a probability, nor even upon a mere preponderance of the evidence, but only upon a certainty of the error. Section 683. Decree. A decree declaring the mistake and ordering reformation is generally sufficient to pass title, especially in the jurisdictions where, by statute, a decree is given the effect of a conveyance. In a few instances, however, a conveyance by the defendant has been thought necessary. The principle that when equity once acquires jurisdiction it will be retained for full relief is applicable, and consequently additional equitable relief, such as specific performance, foreclosure, or legal relief in damages, may be awarded in the same suit. Under the reformed procedure as it exists in many of the states, the legal relief may be granted without any actual equitable decree. Thus, a plaintiff may sue upon a written agreement, setting forth the facts entitling him to a reformation, and seeking to recover the amount due upon the instrument as reformed. The judgment actually rendered is merely a legal judgment for the recovery of debt or damages. the equitable relief of a reformation not being actually decreed, but being assumed, the purely legal relief is awarded exactly as though the prior equitable relief had been in terms granted. Section 684. Cancellation, scope of the remedy. The equitable remedies of cancellation, rescission, surrender up, and discharge of instruments are one and the same remedy, depending upon the same rules. They are frequently accompanied by an injunction against a suit at law upon the instrument, or against the negotiation or transfer of the instrument to other persons. The chief occasions giving rise to the exercise of this jurisdiction are mistake, fraud, including constructive fraud, in its manifold varieties, and illegality, but this enumeration is by no means exhaustive. Section 685. Adequate remedy by defense or action at law. The jurisdiction of equity to grant the remedy of cancellation exists and will always be exercised when it is necessary to protect or maintain equitable primary estates, interests, or rights. Where, however, the estate, interest, or right is legal, the jurisdiction always exists, but its exercise depends upon the adequacy of the legal remedies, a party being left to his affirmative or defensive remedy at law, where full and complete justice can thereby be done. A doubt was formerly entertained as to whether a court of equity ought to exercise its jurisdiction to order instruments absolutely void at law, and not merely voidable, to be delivered up and cancelled, since the legal remedy of a party was adequate and complete, and no case was presented for equitable interference. But it is now well settled that jurisdiction will be exercised in such cases, except where the invalidity of the instrument is apparent on its face. Subject to this limitation, the remedy at law is usually inadequate, and the jurisdiction of equity exercised as a matter of course. 1. Where the invalid instrument creates a cloud on title to land. 2. Where the instrument is negotiable and not yet mature, because in such cases if the present unlawful holder, although the legal defense to an action by him would be perfect, should transfer the security to a bona fide purchaser, such legal defense would be cut off. In this case, it is usual to enjoin the transfer of the instrument, as well as to order its surrender. Where, however, the instrument against which the complainant claims a defense does not fall within either of these classes, where it is not a cloud upon the title to land, and where there is no danger that the defense will be lost by the transfer of the instrument to a bona fide purchaser, there is the sharpest conflict among the authorities as to the propriety of the remedy of cancellation. On the one hand, it is held, in a considerable group of cases, that the danger of loss of evidence in support of the defense, through the intentional delay of the holder of the instrument in bringing suit thereon, is sufficient to warrant the exercise of the jurisdiction, and this, too, even where the holder of the instrument has already brought suit at law upon it, since the prosecution of such suit is within his control, and may be delayed or withdrawn, and another brought at a time when an unconscionable advantage may be taken. But on the whole, the majority of the cases repudiate the idea that the mere danger of loss of evidence to support a future defense is a sufficient ground for immediate relief in equity against the instrument, unless some special circumstances are shown which render such delay more than ordinarily hazardous, and a fortiori, refuse to interfere where an action at law has already been begun upon the instrument, and the defense may be interposed therein. In another group of cases, in many of which the complainant is a vendee of land or chattels, the question of inadequacy of the legal remedy concerns, not a legal defense in a future action against the complainant, but the alternative legal remedy that may be pursued by him, as for recovery of the purchase price, of damages for deceit, and the like. This question, in the main, depends upon the special circumstances of the individual case. It is well established that a stockholder may procure cancellation of a subscription obtained by fraud, since a remedy which did not destroy his status as stockholder would leave him subject to liabilities imposed by law. Section 686. Equitable relief where consideration of conveyance has failed, rescission of support deeds. It is, of course, the general rule that the mere failure by a grantee to perform a promise, which formed the whole or part of the consideration inducing an executed conveyance, gives rise to no right of rescission in the grantor, either at law or in equity, unless such promise amounts to a condition, and it is a rule of construction that, in case the language or intention is doubtful. The promise or obligation of the grantee will be construed to be a covenant, limiting the grantor to an action thereon, and not a condition subsequent, with the right to defeat the conveyance. This rule has been found to work a great hardship in the frequent cases where an aged person has conveyed all his property to a son or other relative on the consideration, often oral, that the grantee shall support and care for the grantor during the remainder of the grantor's life, and the grantee, while retaining the land, has abandoned the performance of his obligation. Legal relief by periodic suits for damages is manifestly inadequate, and many courts have sought to evade the operation of the rule and afford the grantor some equitable relief that should include the reinvesting of his title to the land. Thus, the courts of Illinois, in a series of cases, have decreed rescission, based on a legal presumption of the grantee's fraudulent intention, at the time of procuring the conveyance, to fail in the performance of his obligation. In Wisconsin and Indiana, the grantee's promise, though oral, is treated as a condition subsequent, on breach of which the grantor has the right of re-entry, and, generally, the right to have his title quieted or the cloud cast thereon by the conveyance removed. In a number of other states the courts have not been at pains to bring the case within the analogy of any principle of general application, but have granted cancellation or a reconveyance on the mere ground of the hardship of the situation and the inadequacy of the legal remedy of damages, thus adding to the long list of constructive frauds a new and independent species. In still other states equitable relief in this class of cases is refused, in obedience to the general rules stated at the beginning of this paragraph. Section 687. Ratification. Laches. One who ratifies a transaction, after obtaining knowledge of the facts, cannot come into equity for cancellation. This doctrine rests upon a distinct principle of public policy, that all that justice or equity requires for the relief of a party having such cause to impeach a contract is that he should have but one fair opportunity, after full knowledge of the rights, to decide whether he will affirm and take the benefits of the contract, or disaffirm it and demand the consequent redress. Ratification may be either express, or implied from the conduct of the parties. Any dealing between the parties inconsistent with an intention to rescind, such as payment or receipt of the purchase price, taking the benefits of the contract, or exercising dominion over the property, and the like, after knowledge of the facts, is evidence, more or less conclusive, of a ratification. The act must be unequivocal, however, and must show an election to retain the property, after discovering the deceit, before the right to rescind is gone. The doctrine of laches applies to this, as to all other equitable remedies. Consequently, unexcused delay, coupled with other circumstances, such as change of position, loss of evidence, and the like, will bar relief. Where the right to rescind arises out of undue influence, no ratification can be inferred and no laches can be imputed so long as the original undue influence remains. Section 688. Restoration of consideration. In order to obtain relief, the complainant must restore the other party to the condition in which he stood before the transaction. This requirement is based upon the maxim that he who seeks equity must do equity. In cases of fraud, if the defendant's act has prevented a complete restoration of the status quo, he cannot, in justice, urge this fact as a defense to the rescission, but in other cases, such as mistake, it would seem reasonable that the status quo should be completely restored as a condition of equitable relief. Even in an action at law, if the thing received by the defrauded party be of no value, or if by reason of the act of the fraudulent party a return be rendered impossible, a return or tender is unnecessary. So, also, where by natural causes or reasonable use the value of the property is diminished, and perhaps where it is necessarily destroyed in discovering the fraud, the fraudulent party must receive it in its depreciated condition. Neither is a party obliged to return that which he will be entitled to retain, even though cancellation be decreed. As to whether a return or tender of the consideration, whether money or other property, must be made before suit, the courts are very evenly divided. Many of the courts have, in dealing with this question, completely lost sight of the plain distinction between the equitable remedy of rescission or cancellation, where, as in all equity decrees, complete relief is awarded to the defendant as well as to the plaintiff, and the legal remedies, based upon rescission of a contract by the act of a party thereto, where, in the act of rescission itself, the plaintiff must restore or attempt to restore the consideration, since, in legal theory, the ex parte act of rescission reinvests him with the legal title to the thing for the possession of which he subsequently sues, and must, therefore, be conditioned upon a surrender of the thing already received by him in pursuance of the transaction which he thus avoids. Restoration or tender before suit is thus a necessary element in legal rescission, but is wholly superfluous as a prerequisite to the commencement of a suit in equity for rescission or cancellation, and insistence upon it as such prerequisite often works a complete denial of justice. In nearly half the states, however, where the question has arisen, it has been settled that the legal requisite of tender applies in full force to the equitable remedy of rescission or cancellation, except in the few circumstances mentioned above, where return of the consideration is impossible and is excused.